Well, greetings again. Today we're going to shoot lesson 7. This is where the courtroom strategy begins, with courtroom procedure. And the courtroom procedure is going to begin with a motion hearing. It's the first thing that you're going to do. And this is where the courtroom becomes fun, because by now you should have a little knowledge and a little information. And you know, a person who has knowledge and information becomes a dangerous person to the establishment or to the government. And it's always been that way from the Tower of Babel until the present time. The man that can walk in the courtroom and tell the court what it is he has on his mind, and as I call it, staking out your 9 square feet and planting your feet firmly and bringing the size of government down to one man against one man. As I see it, one of the biggest problems that citizens have is trying to take on the entirety of the bureaucracy. They take on the entirety of the IRS. They take on the entirety of EPA. And now we're going to learn today that that is not the way we're going to proceed. That the judicial branch of government is a third, totally independent branch of government with the equal amount of power with the executive and the legislative branch of government. And as a citizen, I can sit here on the courtroom floor and tell you plainly, I don't give a damn what laws the legislature passes. And I don't care who the governor is. And I don't care who the executive officers are. Because the question isn't what laws and who's carrying them out, but who do those laws apply to? Now, as I've said before, one of the first things that you raise is, does the law apply to me? Well, in the state of Idaho, we, the citizens, are in a very advantageous position because we don't have grand juries here. That's a violation of due process of law. We prosecute by information and complaint felonies, which is a violation of law. We prosecute here with prosecuting attorneys instead of public prosecutors. That's a violation of law. All of these are violations of due process. You couldn't get a conviction in the state of Idaho against a knowledgeable pro se until halfway through the millennium, because it may take that long to get the laws changed and in conformity with our Constitution. Your theory of the case is based upon the motions that you're going to put into the court prior to going to trial. You may never have heard the word motion or brief or affidavit or theory of the case. And that's what we're going to do today. We are going to present before Judge Curtis in this courtroom our theory of the case. 50% of your case is wrapped up in motions, briefs, and affidavits. If you cannot read and write, if you cannot compose, if you cannot put down on paper your theory of the case and the methodology by which you want to proceed, I think you're going to be at a tremendous disadvantage. I wouldn't go so far as to say that you can't win or you can't proceed or you can't go forward. I'm just telling you that half of your victory is going to be wrapped up in being able to present these motions. Now, there's also the courtroom strategy, or that is the procedure. Now, you can always tie the court up on procedure even if you're wrong. And procedure is the particular objection you're going to make, and they're wrapped up like this. Let's say you come into the courtroom and they're prosecuting you for a felony. Now, one of the first things you're going to raise then is the subject matter of how is this court, or how are your adversaries moving forward against you? Is it with an information? Is it by complaint? Or have you already been to a grand jury and has the grand jury handed down an indictment? Well, in Idaho, I can't remember when we've had a grand jury, but the last I heard was 18 years ago. So using Idaho then as our test state, you can go through your state and find out, or check in with your law library and find out whether or not you've had any grand juries lately. The grand jury should be the first step in an infamous crime or a felony prosecution. Now remember, when you're in the traffic court, we're not talking about rights, we're talking about administrative law. Administrative law is a contractual agreement, and the punishment or the penalty is prescribed in the statutes, and it's the penalty clause of a contractual agreement. Now remember, we have stepped outside the realm of equity and contract, and we have now stepped into the realm of the common law. And the question now before us is, what loss of life, liberty, or property has transpired to bring a cause of action before this court? So as we begin with Judge Smith today, we're going to ask that question, and we have a defendant. And that defendant is going to defend a motion. He has called a motion hearing, and he's filing motions, and he's bringing before the court's attention questions like, counsel. How do I get counsel? What kind of counsel? What about the affidavit in support of the complaint? What about the complaint itself? What about my right sua sponte, my affidavit of poverty? What about the jurisdiction of this court? And all of these motions that are brought before the court's attention are in effect saying, Judge, if I don't have counsel, I can't proceed to trial. What we're in hopes of here is that the court, that is the trial court itself, will violate your rights. Because if the trial court would tell you, you cannot have counsel now, sit down and shut up, you've just won your case. Because your theory of the case is due process, common law, loss of life, liberty, or property. What are the charges? How do I obtain all of my rights? And suddenly it's not a question any longer of did you rob the Circle K store, but the question in the appeals process is, well, while you were trying this man for robbing the Circle K store, why did you beat a confession out of him? Why did you deny him counsel? Why did you deny him due process? Why did you deny him equal protection? And suddenly, as the case is in Idaho, the issue isn't what did you do, but why didn't you prosecute him pursuant to law? Because remember, the jailers, the judges, the police, the prosecutors, everyone who's connected with this case has to do so pursuant to law, pursuant to rule, pursuant to the way it's set down over the ages by the custom and usage of the common law. Are you beginning to see why now prosecutors and judges don't like the common law? Because it's time-consuming and it's cumbersome and it's predicated upon the proposition or the preposition that we all know the Ten Commandments and we all keep the Ten Commandments, we all obey the Ten Commandments, and who is this government to come along and say that one of us has violated one of the tenets of the Ten Commandments? And if this is so, the burden of proof lies upon the government, and they must prove that this man is guilty, and guilty beyond a reasonable doubt, and guilty in front of a trial per pious or a trial of the country, a trial in front of the citizens. But in Idaho, we don't have trial in front of the citizens. It's our government that determines who will be brought to trial. It's our government that determines who's going to be prosecuted and how, whether it's by information or complaint, whether it's by grand jury. And they've eliminated the grand jury because they don't need the people out there to run the courts or to run the judicial process. You people out there are slaves and serfs. You're feudal serfs on the land. You sit down and shut up. We'll decide for you what's good for you. Fortunately for us, our Constitution still works and it's still in full force and effect, and you can demand it and you can use it. But in order for you to use it, you must object timely and you must demand your rights timely. And so now as we begin, we're going to look at a man who is in the process of demanding his rights timely. He's been arraigned. He's either posted bail, bond, or he is released OR. And his name is John Smith. And John Smith is going to come into the very first hearing that he has motioned up before Judge Curtis. And now he's going to present his theory of the case and his demands for due process of law. Let's watch now as John Curtis, the judge of Smith County, Idaho, proceeds with this motion hearing.
This is the time and place set certain for a motion hearing in case numbers 156228, 156229, and 156230. Representing the state in this case is Mr. Ray Johnson. Is the state ready to proceed?
Yes, Your Honor, the state is ready to proceed.
The defendant in this case is Mr. John Smith. Mr. Smith, are you ready to proceed?
Yes, Your Honor.
Mr. Smith, this is your motion hearing. I see you have quite a voluminous file here. How do you wish to proceed on this?
Well, Your Honor, the first issue I'd like to take up this morning will be notice and demand for counsel of choice. I have motion number 1.
Okay, proceed, Mr. Smith.
Thank you, Your Honor. First of all, I'd like to show the court, or tell the court for a matter of record, that I am a free and natural person, and I appear especially and not generally. My first demand is for counsel of choice, an unfettered counsel in this matter, as guaranteed to me by the 1st, 5th, 6th, 8th, 9th, 10th, and 14th Amendment of the United States Constitution. That is my demand.
Do you have anything to support this demand, counsel?
Yes, I have an affidavit, a brief in support of the notice of demand for counsel of choice. It numbers 25 pages. It is motion number 2.
I've read your motion, Mr. Smith. What do you want to say about it?
Well, it's usually the state's contention that I have to have a licensed attorney, somebody that's a member of the Bar Association. It's my demand that, or contention, that the word counsel was used purposely to mean that I could also be represented or assisted at this table by a friend of my choice that doesn't have to be licensed and a member of the State Bar Association. These rulings come back from the 17th century. It states here that counsel meant a person could also represent themselves or have the co-counsel or assistance of a friend. And that's my demand upon this court. This brief in support of is quite lengthy. I could discuss the whole thing, but if the judge has already read the matter or the arguments enclosed in this motion, I'd like to hear what the prosecutor's objections are, and I'll try my best to overcome those.
Mr. Johnson?
Thank you, Your Honor. These arguments are entirely spurious and off point, and it's quite evident that the defendant has had ample opportunity to secure licensed counsel pursuant to the law. These people coming into the courtroom acting pro se have been coming into the courtrooms with nothing more on their mind than disrupting the courts, obstructing the lawful process of law. They're obviously incompetent, and the legislature has decreed in Idaho Code 3-104 and 3-420 that only a licensed lawyer who's been to law school and has the knowledge and the ability to move forward should represent people in the courts. Mr. Smith has been given ample opportunity, Your Honor, at county expense to have a public defender come in and represent him. And it's my understanding that, and from what I read in these briefs and motions, that he's absolutely refusing even to have county-paid counsel. And I say that this is absolutely ridiculous. The very idea that the taxpayer should even represent him should be repugnant. But when they offer to do it at county expense, and then this man turns it down and then uses this as an argument whereby he can then claim that he's being denied counsel, is absolutely spurious. Now, if Mr. Smith wants counsel, I would suggest that the court remind him that he has waived his right to counsel, and that he has taken it upon himself to be counsel of his choice pro se. And if he's going to appear pro se, he's to be held to the same standards as any of the rest of us who are members of the bar. And I need not remind you, Your Honor, that you too are a member of the bar. And you know the difficulties of coming into the courtroom without knowledge, without ability, without training, and trying to proceed without competent counsel. And that's why the legislature, in its wisdom, has decided that we cannot have just the average ordinary citizen coming into the courtroom trying to conduct these kinds of complicated proceedings.
It wouldn't be fair to the defendant, for one thing. It's necessary for the state to help Mr. Smith, and I agree that Mr. Smith should be helped. And the government's offer that he should be represented by a public defender still stands. And I would recommend, if nothing else, Your Honor, that this court order Mr. Smith to take counsel of the public defender, because by his very arguments he is showing himself to be incompetent to move forward on his own initiative. So we have no objection, Your Honor, so long as his counsel is licensed and approved by the Bar Association of the State of Idaho.
Smith?
Your Honor, I find numerous problems with this. First of all, let the record show, or let the prosecutor show me where I ever waived my right to counsel, be it a licensed attorney or otherwise. I've never waived such a right. Second of all, no law or rules can be passed by the legislature that would take away my right. I can only lose those rights voluntarily, and I'm claiming this right as a free and sovereign citizen. And I demand this right and will not let go of it for any reason. I think that I have enough experience and ability to conduct half my case, and I can do so in such a manner that will not disrupt or impede the court. I'm sure the court will have need of only giving me a little patience, providing that they will give me counsel. If the court will deny me counsel, or does deny me counsel, then I will have a much harder time keeping my thoughts straight and my position clear and staying on point, as I have to take notes. Also, there will be several matters such as jurisdiction that I will need absolutely the advice of my counsel, who I demand. Also, I believe that it's a matter that Warren Berger once stated that 90% of all lawyers are incompetent to practice law. That is also my feeling. I absolutely cannot have a public defender. Their record just is not consistent with my intentions of winning. And on that, if the court denies me counsel of choice, let me state that I will object and that I will lose if I am forced to accept anything but counsel of choice.
And Mr. Smith, here you are. Where is your counsel? This is a hearing.
Well, my counsel is sitting right over here behind me.
Mr. Smith, I see no reason why you shouldn't have counsel of your choice. If the prosecutor objects to this, then he can take it up with the counsel. If he feels that he shouldn't represent you, that's a matter between the prosecutor and yourself and your counsel.
Thank you, Your Honor.
Well, Your Honor, I want to object most strenuously to this. It should be obvious that Idaho Code comes into play here. The 3-104 is very clear and emphatic that he has to be represented by a member of the Idaho Bar. And are we to just let anyone come into the courtroom and represent citizens and practice law? What is to protect the citizenry from the unauthorized practice of law? And what is it that's going to protect the citizens from the kind of debauchery that we've seen in earlier decades and earlier centuries when just anybody is allowed to represent someone?
Mr. Gordon, I've made my ruling. If you wish to object to it, the court will note your objection, but my ruling stands.
Well, I'll file a petition with the court and object to this most strenuously.
Now we've had an opportunity to watch a young fellow in action. He didn't do too bad a job on that presentation. I think, though, that if I'm the teacher and I'm going to grade it, I'll give him about a C. And the reason for giving the C instead of an A is that the real issue with the counsel is that it's a matter of rights. And also, sitting right in front of the young man is a book called Legal Quotations. If you pull legal quotations out and turn up to about number 203, 204, 205, 206, you can sit there and preach a sermon to that judge that he'll remember if he lives to be 110. There's also some questions to be asked, like, is this court subjected to the determinations of the Supreme Court of the United States, or is this a law unto itself? In this particular case, it wasn't necessary for the young man, Mr. John Smith, to raise any vehement arguments because the judge, in effect, said, I don't care whether Mickey Mouse or Mickey Rooney represents you here, but you're on your own and I'm not going to make the decision. Now, the prosecutor, who's defending the Bar Association, that is the union monopoly, he's the only one that's a party of interest here and doesn't want an unlicensed member of the bar practicing in the courtrooms. Because from coast to coast, that American Bar Association has a stranglehold on our courtrooms, and the only thing that protects us is the Sixth Amendment, which guarantees us the right to counsel, and our federal Supreme Court, and a number of judges between here and Washington who know and understand the counsel issue. The counsel issue is so powerful and so important that to leave it out of a case is to cut out 10% of your defense. If you're going to file 20 or 30 motions, the counsel issue would be number one. I would use counsel long before I would talk about the trial for Pius or the right sua sponte or the grand jury or a number of other issues. The Supreme Court has ruled, and when we do this little clip over again on this counsel, I want to show you a real nasty judge. Now we're going to take a look at a Judge Curtis who's going to come down hard and heavy on the side of the government and deny you counsel. And I'm going to read to you some quotations and some stratagems here that'll win the case. Now in this particular case, John Smith here has not won this case yet. You see, the judge granted him counsel of his choice. And so that issue, that argument of constitutional right was lost to him. The trial judge has said, fine, you can have anybody you want. And we're going to take a look at some of these Supreme Court decisions when we take this up and take a look at John Curtis, the prosecutorial judge working for the state.
Mr. Jones, this is your motion here. How do you wish to proceed?
Well, Your Honor, there are some administrative preliminary matters that we need to take up first before we can proceed on this motion hearing. First of all, I'd like to have my counsel come over and sit at this table.
Is your counsel a licensed lawyer, Mr. Jones?
You'll have to ask him that, Your Honor.
I'm asking you, Mr. Jones.
Well, Your Honor, I think we've covered this matter before in arraignment. I don't feel that
Is your counsel a licensed lawyer, Mr. Jones? Yes or no?
I don't believe he has a license, Your Honor. He's very well qualified to speak. And he's very knowledgeable at law.
Mr. Jones, this matter is true. If you want counsel, you can get a licensed attorney.
Well, Your Honor, I think we have a problem here. I don't see how this court can deny me counsel of my choice. I'd like to give you some quotations, if I might. The right to counsel at a criminal trial is deemed so fundamental.
Objection, Your Honor. I must object to this procedure. We're here to argue a motion hearing, and this man is obstructing and delaying the court. This procedure is totally outside the scope of the rules of criminal procedure of Idaho. Now, if we're ready to move forward in a motion hearing, the state is here and ready to move forward. These delaying tactics and these stalling and obstructionist type maneuvers in the courtroom must come to an end, and I must object.
Mr. Jones?
Well, Your Honor, before I was so rudely interrupted, I'd like to point out that there has been some extremely important case history, Supreme Court decisions on the matter of counsel of choice. And if I'm not allowed to put this in on the record without constant interruption from the prosecution, there is a grievous loss of procedure here.
We'll withhold the decision on this objection, and you may proceed with your statements if you make them brief.
Yes, Your Honor. I think we can cover this very quickly. For example, Burgett versus Texas in 1967, which is rather recent. A conviction obtained where the accused was denied counsel is treated as void for all purposes. I think that's a landmark decision there. And here's another one, Mempha versus Ray. That's another one in 1967. The right to counsel exists not only at the trial thereof.
What is the citation on that?
It's Mempha versus Ray, 389 U.S. 128.
Thank you.
The right to counsel exists not only at the trial thereof, but also at every stage of a criminal proceeding where substantial rights of a criminal accused may be affected.
Well, Mr. Jones, we have denied you counsel. Anytime you wish, you may get counsel of your choice. I'm going to sustain an objection to this.
Oh, thank you, Your Honor. I'd like my counsel to come up and sit at the table with me then.
No, I say I'm going to sustain the objection of the prosecutor. You may have your counsel come up and sit with you if he is a licensed lawyer. But you said he's not a licensed lawyer, so he stays where he is.
Well, Your Honor, we have some other important case law concerning this.
The decision is made. Idaho Code says you must have a licensed lawyer, and we're under Idaho Code here, so that's what we're going by. I have no alternative.
Okay. We've just taken a look at Mr. Jones arguing the same position, only this time raising some Supreme Court arguments and some case law that's already been decided. You'll notice that the prosecutorial judge in this case took the side of the prosecutor who sat dumbly by, which is what is generally the rule of thumb here in the state of Idaho. The lower court judges take their cue from the state Supreme Court, which tells them not to make any decisions that make waves because they're basically incompetent. Now, actually, it's my position that a judge should make decisions based upon the Constitution, and more specifically, the Supremacy Clause. And the reason for that, a judge should have the right to make whatever decision that he sees based upon the Constitution and his understanding of it. And in the event that either party is dissatisfied with the decision, it's an appealable issue. And if the government doesn't like an unlicensed lawyer sitting there, then let them appeal that issue and let the Supreme Court of the state then overturn or overrule or make that case law. The problem that we're having here is that the courts have already decided that. And the lower court judges take their cue from the Bar Association. Now, we just heard Mr. Jones read 4 or 5 Supreme Court dictates, which, whether it's dicta or original, I can't tell, because they're quotations. But in any event, the Supreme Court of the United States has said that if a man is denied counsel, then the verdict is null and void ab initio. It's dead. Period. It's the end of the argument. And so here's Judge Curtis just denied Mr. Jones any counsel. Mr. Jones has just won his case. It'll go to the jury, and the jury will find him guilty, and then the appellate courts of Idaho will uphold the lower court conviction, because after all, it was the higher courts in the state of Idaho who told the lower court how to decide. But when it gets into the federal courts and the Supreme Court sees it, they'll reverse it out. Is it any wonder that Judge Berger said that 90% of the lawyers are incompetent in the United States? The judges come from the ranks of the lawyers. And so here we have incompetent lawyers coming from incompetent law schools who are then chosen to become incompetent judges, who then in turn make incompetent and faulty decisions, which then in turn go to the Supreme Court, and the Supreme Court sits there and shakes its head and says, I can't understand why we get all of these Mickey Mouse and trivial cases coming before us, like Brown versus Texas. We'll grade Mr. Jones with a C. He really wasn't very vociferous, and he really wasn't the belligerent claimant in person. And then when it was all said and done, he forgot to make his objection. Let the record show, Your Honor, I object to this procedure and to the process and of being denied counsel and counsel of my choice. Because, you see, counsel is a matter of rights, and where rights are secured by the Constitution, there can be no rulemaking
or legislation which would abrogate them. Now let's take a look at a little more polished individual who's going to take control of the court. If you'll notice in the case of Smith and Jones, the judge is in control of the courtroom. Let's see if we can take control of the courtroom away from Judge Curtis, and let's see if we can proceed forward demanding our rights with a belligerent claimant in person. Let's see how this scene comes down.
Mr. Cook, this is your motion here, and how do you wish to proceed in this?
Your Honor, I think first of all, before we proceed with the motion hearing, it's necessary and imperative that we take up at least one, if not two, administrative and procedural matters prior to moving forward.
I'll proceed, Mr. Cook.
Well, first problem that I find here is that the jurisdiction of the court is improper. The court is improperly set, and I want to challenge the jurisdiction of the court. In order for me to do that, to prevent granting jurisdiction to a court that is inferior in its process, I've got to challenge the jurisdiction of the judge pursuant to Rule 2.2 and demand counsel of my choice all at the same time. Since it's impossible to do three things at the same time, I would like the court then to take judicial notice of this problem and direct the defendant in the procedure that the court would like these three issues decided.
Mr. Cook, this is your motion here, and if you can't decide in which order to proceed, maybe you ought to dispense with them.
Well, thank you, Your Honor. I'll assume then that you're going to allow me to determine the three items. The very first item that has to be brought up, as I see it, pursuant to the rules, would be Rule 2.2, which is a challenge to the jurisdiction of the trial judge to sit in this proceeding. Are you qualified to sit here as an attorney magistrate, or are you a lay judge?
I'm an attorney magistrate, and I'm qualified to sit.
Have you been approved by a majority of the district court judges and a majority of the Supreme Court judges?
If I hadn't been approved, I wouldn't be here, Mr. Cook.
Well, there are some judges that are not, so I'd like to enter for the record this objection that if at some time in the future we find that pursuant to Rule 2.2, you for some reason have not been voted upon either by the Supreme Court or the District Court, that I would use that as an appealable issue for reversible error. I guess with that issue out of the way, we take up the next issue. And before we can take up jurisdiction, we must now solve the counsel question. If you'll notice, Your Honor, I filed a brief and a motion in support of my demand for counsel. The issue of counsel is so important that the Supreme Court of the United States and the Brotherhood of Railroad and Locomotive Engineers versus West Virginia has decided that a defendant must have counsel and must have counsel even if the words next friend.
Mr. Cook, we're not under the Supreme Court here. We're under the Supreme Court of the state of Idaho, and the statute's made pursuant thereto. And the statute says you must have licensed attorney.
Is it the position of this court that it's better able to read my mind and to determine what I'm going to say before I say it?
Sometimes, yes.
Well, Your Honor, I have not even made mention of licensed versus unlicensed attorney. How can you presuppose that I'm going to talk on that subject at this time?
Mr. Cook, you have made the notice and demand for counsel of choice here, filed with the court on July 12th this year, and if you want counsel, the only counsel you may have is licensed attorney. Now, if I appear to be presumptive, I probably would, because that's the only kind of counsel you may have.
Well, Your Honor, we're not into the motion hearing yet. We're still deciding the administrative and procedural matters, and I can't move forward and argue jurisdiction without counsel until we can argue the counsel issue or determine whether or not I'm going to have counsel. We haven't entered into the hearing yet, so may I proceed?
You may proceed.
Thank you, Your Honor. The Supreme Court of the United States, it's my contention, has absolute jurisdiction in all appellate matters, and that the decisions of the Supreme Court are binding upon this court. Now, did I understand you to say that the decisions of the Supreme Court of the United States can be dispensed with or ignored by this court?
That's not what you heard me say. Do you wish me to repeat my words?
Would you please?
My words were that we're under the Supreme Court of the state of Idaho, and the laws made pursuant thereto. The laws made pursuant to the Supreme Court and the Constitution of Idaho say that you may only have licensed attorney to represent you.
We haven't approached the issue of licensed attorney yet, Judge. We are still in administrative and procedural matters.
Did I hear you use the word counsel?
You heard me use the word counsel, but I haven't brought up...
Licensed attorney.
That's an issue to be discussed when we're talking about the motion in brief, not in administrative and procedural matters.
You may proceed.
Thank you, Your Honor.
However, I want you to bear in mind that when you use the word counsel, you are speaking of licensed attorney.
Well, now, I'm not going to get into the issue of definitions just yet. Before I can move forward with the motion hearing, I'm contending that I need counsel to sit with me and to assist me in arguing the position of counsel, because my position is that this court has no jurisdiction in this matter. And therefore, the issue of counsel must be decided before we can move forward in a motion hearing in order for me to set forth my theory of the case. If my theory is correct and this court has no jurisdiction, then this court does not have the capacity to even listen to the issue of counsel. And in order for this court to first listen to whether or not it has the capacity to listen, I'm contending that I've got to have counsel, and effective counsel, pursuant to the maxims and dictates of the Constitution of the United States in the Sixth Amendment, and the decisions as handed down by the Supreme Court of the United States in the following cases. And those are Gideon versus Wainwright.
Are we still discussing? Mr. Gordon, Mr. Cook, excuse me. I keep getting confused with Mr. Gordon over here. Looks a lot like you. If you're going to act thus in my court, I may have to hold you in contempt. You must show respect for the court. Now, are we in administrative and procedural matters, or are we in a motion hearing?
At the moment, Your Honor, I don't know where we are because you've interrupted me 3 times and I've lost my train of thought, and I really don't know where I am.
Well, I'll tell you where we were. We were talking about counsel. Now, if you wish to dispose of the issue of counsel, let's do it right now. We'll hear any arguments you have on counsel. We'll decide that issue, and then we'll proceed.
Well, I asked you before we began how you wanted to proceed, and you said that you were going to leave it up to me. And I assumed that when you left it to me that we were going to decide the qualifications of the judge pursuant to Rule 2.2, then whether or not counsel would be seated to decide the third issue of jurisdiction before we entered into the formal proceedings of the motion hearing itself.
Mr. Cook, you are appearing here pro se, and with the understanding that by appearing pro se, you know what the procedures are, and I had assumed that you knew. Now, if I have to help you, first issue we'll decide is counsel. Whether you have counsel, whether you have counsel appointed by the court, or you have unlicensed counsel or licensed counsel, you have arguments to put forth to the court on that issue. Let's hear that issue now and get it out of the way.